Have you ever wondered how broadcasters pay thousands of crores for sports tournament? Who owns the broadcasting rights of the IPL? How do OTT platforms acquire the streaming rights? What happens when broadcast rights expire? What contracts are signed between players, franchise, broadcasters, sponsors, and event organizers? Now, in this comprehensive sports law masterclass, I will explain the legal and commercial ecosystem behind the sports broadcasting, OTT rights, overseas media rights, player rights, franchise contracts, sponsorship agreements, image rights, merchandising, advertising, your licensing, etc. So, hi everyone, I'm Advocate Aishwarya Sandeep, and welcome back to Law School Uncensored. So, today we are going to discuss one of the most fascinating and commercially significant areas of modern law, that is your sports broadcasting rights and sports media law. So when we watch a cricket match, let's say a football tournament, the Olympics, the Wimbledon, Formula One, or any other sporting event, most of us simply, we just switch on our television or open an OTT platform and start watching. But have you ever stopped to think about why only one platform has the exclusive right to show a particular tournament while the other platform does not? So why does the one company which pay thousands of crores merely to broadcast a single sporting event? Why are there different broadcasters for different countries? And why do some matches appear on television while others may be available only on streaming platform? How are these players getting compensated in their advertisements? Who owns the footage of these cricket matches? Can someone simply upload match highlights on YouTube? Can another television channel record the live broadcast and then telecast it again? Now, what happens when the broadcasting contract expires? These questions are something that may appear very simple, but the answers lie at the intersection of your contract law, intellectual property law, competition law, media law, sports governance, and commercial negotiations. Today, I will explain you the complete legal ecosystem behind the sports broadcasting. By the end of this video, you will understand why sports broadcasting is considered as one of the biggest businesses right now in the world. You will understand why sports lawyers have become indispensable to sports federation, broadcasters, OTT platforms, sponsors, advertisers, athletes, and investors. Let's begin with the most fundamental question that everybody has in their mind. What exactly are your broadcasting rights? So, sports broadcasting rights are the legal rights which are basically granted by the organizer of the sporting event that permit a broadcaster of a digital platform to record, transmit, stream, distribute, and commercially exploit the live recording or recorded coverage of the sport event. Now, think of your broadcasting rights as a license. The organizer owns the commercial right over the event. So instead of broadcasting the event themselves, what they usually do is they license those rights to another company for a fixed period and for a specific territory. Now the broadcaster pays enormous sums of money because sports attracts millions of viewers, and millions of viewers means a lot of revenue in advertisement. So more viewers usually translate into higher advertising revenue, increased subscription, stronger brand visibility, and great commercial value. That is why sports rights have become one of the most valuable assets in the global entertainment industry. So who owns these broadcasting rights? Now, most people believe that the broadcasting rights, that the players, they own the broadcasting rights because they are the one who are playing the game. But technically, that is not correct. Generally, it is the organizer of the tournament who owns the commercial rights, which is associated with that event. For example, if the cricket board organizes an international series, it is usually the media rights relating to that series, which is owned by them. Now, similarly, when a sports league organizes a tournament, it owns the commercial right associated with that particular competition, unless those rights have already been assigned or licensed under another agreement. Now, the organizer may then sell or license the rights to broadcasters through competitive bidding process. Just like how you have bidding process for your players, similarly, you also have it for the broadcasting rights. Now, these rights can be worth billions because broadcasters expect to recover their investment through advertising revenue, subscriptions, fees, sponsorship agreements, and digital monetization. Now, moving on, let's talk about different types of broadcasting rights. So, sports broadcasting rights are not limited to television. They are divided into several categories. The first is, of course, your television broadcasting rights. Now, these rights, they permit a broadcaster to telecast a sporting event through satellite cable or television. Okay. So, the second category you have is your digital streaming rights. Now, these rights authorize the online streaming, through your websites, mobile applications, smart TVs, and your connected devices. The third category you have is your OTT rights. So, OTT is basically over the top platforms. These includes your subscription-based or advertising-supported digital streaming services that deliver content directly through the internet without requiring your traditional cable or satellite distribution. So, OTT rights recently have become increasingly valuable because audiences are now shifting from conventional television to your internet based viewing. Now, the fourth right that we have is your radio broadcasting right. Now, although radio has become very less dominant than television and your digital streaming, it radio commentary it remains commercially valuable, especially for the audiences who consume sports while traveling. Another important right that we talk here about is your highlight rights. You may, if you're a regular sports viewer, you know that there are highlights which come while the game is being broadcast. So, who owns those rights? Sometimes a broadcaster does not obtain the right to stream the entire live event, but it acquires only the right to broadcast selected highlights after the match concludes. For example, some news channels, they have analysis, they have discussions after the match has concluded. In that case, they do acquire the highlight rights. There are also archival rights, which allows historical footage to be reused in documentaries, promotional campaigns, anniversary programs, and educational content. So each category is negotiated separately because every right it carries a commercial value. Now let's talk about exclusive rights and non-exclusive right. So one of the most significant concepts in sports media law is the distinction between exclusive rights and non-exclusive rights. So your exclusive rights mean that only one broadcaster may telecast or stream the event with the agreed territory. No competing broadcaster can legally broadcast the same event during the contract period. Now, this exclusivity, it often commands, a much higher price because it eliminates effective, direct competition. Now, non-exclusive rights are, on the other hand, they permit multiple broadcasters to broadcast the same sporting event simultaneously under separate agreements. Now, these rights, they generally generate a lower licensing fees because viewers have multiple viewing options. So whether rights are, whether these rights generally generate lower licensing fees because viewers have multiple viewing options. Whether these rights are guaranteed exclusively or non-exclusively, it entirely depends on the commercial strategy, which is adopted by the organizer. Let's move on to the territorial rights. I'm sure you must have heard this concept a lot of time. So a broadcast right is also divided according to the geography. A broadcaster purchasing rights for India does not automatically acquire the rights for Australia, England, US, South Africa, or the Middle East, or any other country. Now, each territory is licensed separately. Now, why? Because of the audience size, the advertising market, language preference, subscription rates, and commercial demand. It may vary from country to country. Consequently, organizers, they also want to maximize the revenue by selling the rights territory by territory. So, for example, one broadcaster, he may acquire the Indian rights, while another one, he obtains rights for Europe, third one maybe for North America. Now, this territorial licensing strategy, it significantly increases the commercial value of global sporting events. Now, why exactly are broadcasting rights worth billions? Many people ponder why broadcasters pay such an enormous amount. Now, the answer lies in economics. Live sports are among the very few forms of content that audience generally prefer to watch in real time. Unlike movies or television series, sporting events often, they lose much of their value after the final result is known. So this creates, exceptionally high demand during the live broadcast. Now, broadcasters recover their investment through advertisement sales, premium subscriptions, sponsorship packages, branded content, licensing arrangements, syndication, and cross-platform distribution. For advertising, the sporting event provides access to millions of engaged viewers simultaneously. And this makes sports broadcasting one of the most profitable sectors with the media industry. Now, uh, we understood what sport broadcasting rights are, who owns them, why broadcasters spend billions of dollars to acquire them, and how exclusive or non-exclusive, you know, your territorial and digital rights operate. Now, let's move on to, another step. Let's take another step and understand how modern sports broadcasting ecosystem functions in this age of digital technology. If 20 years ago someone wanted to watch a cricket match, they only had one option, which was the television. And we are the 90s kids, we only watched matches on Doordarshan. Today, the same match can be watched on a mobile phone, laptop, smart television, tablet, gaming console, or even through your connected devices. This transformation has fundamentally changed the entire way the sports rights are negotiated, valued, and commercialized. The emergence of OTT platform has created an entirely new legal and commercial framework. So, what exactly is an OTT platform? So, your OTT or your over the top, it refers to internet based content delivery services that distribute content directly to consumers without relying on traditional cable or satellite television operators. Instead of waiting for a television broadcast, viewers can stream, live matches through applications and websites from virtually anywhere with an internet connection. Now, this shift has made OTT rights one of the most valuable assets in sports law. Today, many viewers, particularly the younger audiences, prefer watching sports on their smartphones. Sorry, they enjoy features such as multiple camera angles, live statistics, live replay, instant replays, multilingual commentary. You have your personalized notifications and interactive experience. So consequently, OTT platforms are willing to pay substantial amounts to secure exclusive digital rights. However, they are not casually acquired. They are governed by legal agreements known as media rights agreement. So, a media rights agreement is basically the backbone of every broadcasting transaction. It defines the legal relationship between the broadcasting rights holder and the broadcaster. So, every clause in this agreement, it determines what the broadcaster is permitted to do, and equally important, what it is prohibited from doing. Now, this agreement, it also defines what is the duration of the uh, license, the territories that it has covered, the permitted platforms, the language of the commentary, quality standards, production specification, payment obligation, advertising inventory, your sublicensing permission, your IPR ownership, confidentiality obligation, dispute resolution mechanism, your termination right clauses, force majeure, and post expiry obligation. For example, if a broadcaster he purchases rights only for India, it cannot legally stream those matches in Australia or the United Kingdom unless the agreement it expressly authorizes it. Okay, if it does so, then they may be liable for breach of contract or for copyright infringement. Now, similarly, if the agreement it authorizes streaming only through a mobile application, the broadcaster cannot automatically extend those rights to social media platform or any third party website without obtaining additional permissions. Now, this demonstrates why sports media agreements are among the most detailed commercial contracts which are drafted by lawyers. So let's now go ahead and discuss the overseas broadcasting agreement. Now, one of the biggest misconception is that sports fan is, just that purchasing broadcast rights means you're acquiring worldwide rights. Now, that is almost never the case. Sports rights are, divided into territories because the commercial value of each market is different. For example, a cricket tournament it attracts massive audience in India, Pakistan, Bangladesh, Australia, England, South Africa, and certain Middle Eastern country where large South Asian communities reside. The value of broadcasting rights in each of the markets it also varies on the audience size, the advertising demand, and the subscription revenue, along with your local competition. So as a result, the organizer he licenses rights separately for each territory. One broadcaster may acquire rights for India, another one maybe for UK, another for Australia, and yet another for US. This strategy it enables the rights holder to maximize the commercial revenue by negotiating independently with the broadcasters in each jurisdiction. Now, the legal agreement governing overseas rights, it also addresses localization, your commentary languages, advertising regulations, consumer protection laws, censorship requirements, and broadcasting standards that differ across countries. Therefore, the broadcaster must comply not only with the contract but also with the domestic laws of every jurisdiction in which it operates. Now, another interesting concept or a new concept in law is simulcasting. So, simulcasting refers to simultaneous transmission of the same sporting event across multiple authorized platforms. A broadcaster may transmit a live match through satellite television while simultaneously streaming it on its authorized OTT application. However, this is only permissible if the license expressly grants both the television and your digital rights. Now, if the broadcaster has acquired only the television rights, it cannot independently simulcast the event online. This distinction often becomes the subject of commercial negotiations because digital audience have become extremely valuable. Let's move further and discuss the sponsorship agreements. Now, many people assume that sponsorship simply means displaying a company's logo during a sporting event. In reality, sponsorship agreements are very sophisticated commercial contracts involving multiple legal rights and obligations. A sponsorship agreement identifies the sponsor, the rights holder, the sponsorship fee, the duration of the arrangement, the promotional rights that are granted, exclusive uh, provisions, branding opportunities, your hospitality rights, your IPR usage, your termination right, compliance obligation, and dispute resolution mechanism. For instance, a title sponsor may obtain naming rights for the entire tournament. Another sponsor may become the official beverage partner, while another secures the designation of official banking partner. Now, these rights are something that is carefully negotiated to ensure that sponsors receive meaningful commercial exposure without conflicting with one another. The agreement also regulates how trademarks, logos, promotional materials, and advertising campaigns may be used. Unauthorized use of a sponsor's intellectual property can also result into legal action. Now, one particularly very important issue in sports sponsorship is ambush marketing. So I'm sure everybody has been watching FIFA, and you have heard about what happened with Gillette or what happened with Levi's. So that is a classic case of ambush marketing. So ambush marketing, it usually occurs when a company attempts to create an association with a sporting event without actually paying for official sponsorship right. As I said, very recent, very common example, Levi's and Gillette in the US with the FIFA tournament. Now, imagine a major tournament has an official beverage partner. A competing company launches an aggressive advertising campaign during the tournament using similar themes, colors, or promotional message, giving consumers the impression that it is connected with the event despite having no official relationship. Now, this undermines the value of official sponsorship. To prevent such practices, organizers include extensive anti ambush provision in sponsorship agreements and may rely upon trademark law, passing of action, copyright law, unfair competition principles, and event specific regulation to protect commercial rights. Now, let us move in to the advertising rights. Advertising is one of the principal reasons broadcasters invest enormous sum in sports rights. Every commercial break, strategic timeout, innings interval, drinks break, your halftime show, scoreboard integration, virtual advertising display, player interview backdrop, and on-screen graphic represents monetizable advertising inventory. Now, these rights are generally governed through the advertising sales agreement between the broadcasters and advertisers. These agreements specify the duration of advertisements, placement during broadcast, frequency of display, and payment schedules, creative approval procedures, compliance with advertising laws, indemnity, cancellation rights, liability to, in case of misleading advertisements. So modern broadcasters, they have introduced this innovative advertising techniques such as virtual boundary advertisement, your digital pitch side branding, your augmented reality graphics, branded statistical segments, and sponsored player analysis. Now, many viewers don't realize that digital advertising elements are governed, through uh, contractual arrangements and intellectual property licenses. Another important agreement in your sports broadcast is the production agreement. Broadcasters, they often outsource the technical production to specialized production companies. If you have seen those, huge cameras, it is not the channel who owns them. It is the production company who is shooting the entire event who owns them. So the production agreement, it defines the production standard, delivery timelines, ownership of the raw footages, technical specification, confidentiality obligation, your insurance requirements, liability allocation, and quality control measures. Similarly, commentators, presenters, analysts, former athletes, and television hosts, they enter into something that you called as talent agreements. Now, these agreements, they regulate the remuneration, appearance, obligation, exclusivity, intellectual property ownership over recorded content, confidentiality, then your code of conduct for the requirement, your social media obligation, and termination clauses. Your sports broadcasting today is not merely about, translating, you're transmitting a match. It involves an entire network of your contractual relationship involving the organizers, your broadcasters, production companies, technology providers, sponsors, advertisers, commentators, photographers, your content creators, social media teams, license agency, and regulatory authorities. Now, every participant contributes to delivering a seamless viewing experience, and every relationship is governed by carefully negotiating legal agreements. So, as lawyers, understanding these agreements is essential because a single ambiguous clause can lead to disputes involving millions or even billions of rupees. Issues such as unauthorized streaming, breach of exclusivity, territorial violations, sponsorship conflict, advertising disputes, intellectual property infringement, or contractual non-performance frequently result in arbitration or litigation. Therefore, sports law, if you see, is not merely about athletes and competition. It is fundamentally about commercial law, intellectual property law, contract drafting, negotiation strategy, and risk management. Um Moving further, now we are going to discuss about the most important stakeholders in the sports ecosystem, the athletes themselves. So every time we watch a cricketer hit a century, or a footballer, scoring the winning goal, or a tennis player, lift a Grand Slam trophy, we often think their career revolves, around just playing the sport. However, from a legal perspective, an athlete is much more than a sports person. Professional athletes, they are also commercial assets, brand ambassadors, content creators, public personalities, and intellectual property owners. So this is precisely why sports lawyers, they play such a significant role in managing the relationship between the players, teams, uh, leagues, sponsors, broadcasters, event organizers, and commercial partners. So let's begin with, the most basic, the player contract. So a player contract, if you see in the legal agreement between an athlete and a sports team franchise, a club, or a governing body, it defines all the rights and obligations of both the parties and governs every aspect of the professional relationship. At the most basic level, the contract, it identifies the parties, the duration of the engagement, the financial remuneration, and the scope of the player's services. However, modern player contracts go far beyond salary and match participation. Now, most of these player contracts obtain clauses relating to performance, obligation, fitness standards, training schedules, medical examination, anti-doping compliance, your disciplinary procedures, confidentiality, media interactions, social media conduct, image rights, sponsorship restrictions, your dispute resolution, insurance, termination, and post-contract obligation. For example, a player may be contractually required to attend all the scheduled training sessions, maintain a prescribed level of physical fitness, because yes, sports is all about physical fitness, participate in promotional events organized by the team, and comply with the code of conduct which is issued by a league or the governing body. Now, failure to comply with these obligations, they may result in fines, suspensions, or even termination of contract. One of the most heavily negotiated aspects of a player contract is the compensation. A player's remuneration may consist of several components. They may be fixed annual salary, there may be match fees, there may be performance bonuses, championship bonuses, signing bonuses, retention bonuses, loyalty incentives, and commercial revenue sharing as arrangements. Some contracts also include incentives for achieving milestones such as scoring a certain number of runs, goals, or points, qualifying for international tournaments, or winning championship. In addition to monetary compensation, many contracts provide benefits such as accommodation, travel, medical insurance, retirement contribution, your training facilities, nutrition support, and access to sports psychologists and physiotherapists. So, the next important part that we are going to talk about is the franchise agreement. Now, professional sports leagues often operate through your franchise models. Under this system, privately owned teams, they participate in competitions which are usually organized by the governing body or the league administrator. Now, the relationship between the league and each team is governed by a franchise agreement. So, this agreement, it grants the franchise right to participate in the league for a specified period subject to compliance with the league regulations. The franchise agreement, it usually addresses your participation rights, franchise fees, revenue sharing, branding guidelines, your scheduling obligations, player registration, salary cap compliance, broadcasting obligation, your sponsorship restrictions, dispute resolution, and termination. Now, the agreement, it also specifies the circumstance in which the league may suspend or terminate a franchise for breaches such as financial misconduct, corruption, match fixing, repeated regulatory violations, or failure to comply with the league rules. Another crucial concept is the salary cap. Now, many professional leagues impose salary caps to maintain competitive balance. A salary cap, it limits the total amount a team may spend on player salaries during a season. Now, the objective is to prevent financially powerful teams from acquiring, let's say, every top player, thereby ensuring greater competitiveness across the league. Now, sports lawyers essentially do play an essential role in ensuring that the player contracts comply with the salary cap regulations. Violations can often result in substantial penalties, including fines, reduction of competition points, forfeiture of draft selections, suspension of executives, or cancellation of the player registration itself. Now let's discuss about image rights, one of the most commercially valuable, aspects of the sports law. So every professional athlete, he poses an identity that carries commercial value. The name, the photograph, the signature, voice, nickname, jersey, your autograph, and even distinctive celebrations may be commercially exploited through licensing arrangement. Now, image rights, when you talk about it, usually refers to the legal right to commercially use the aspects of an athlete's identity. For instance, when a sportswear company uses the image of a famous athlete in an advertising campaign, it must obtain the athlete's permission through an image rights or endorsement agreement. Now, the athlete is compensated for granting this commercial license. However, image rights frequently become contentious because different stakeholders may claim, overlapping rights. So, a player may have personal endorsement agreement while with one brand, and his team may have sponsorship agreement with a competing brand. Similarly, the league itself may have exclusive commercial partnership that require players to participate in, the promotional campaigns. So, to avoid these conflicts, the player contracts often contain detailed provisions specifying which image rights will remain with the player, which licenses to the team, and which rights may be exercised by the league. Another, commercial agreement is your endorsement agreement. Now, professional athletes can earn significant income, through your brand endorsements. These agreements authorize the companies to use the athlete's name, like likeliness, voice, image, or reputation for your marketing and promotional activities. Now, an endorsement agreement generally includes clauses relating to compensation, campaign duration, advertising obligation, exclusivity, intellectual property, ownership, morality clauses, confidentiality, termination right, and dispute resolution. Now, one particular important provision here is your morality clause. Why? Because companies invest substantial amount in celebrity endorsement because they are associating their brand with the athlete's public image. If the athlete becomes involved in criminal proceedings like, doping scandals, corruption, or conducts any damage of the public confidence, the sponsor may terminate the endorsement agreement under the morality clause. This also applies to celebrities these days. Any celebrity, not only sports, your athletes. This protects the commercial reputation of the sponsoring company. Now let's discuss about the merchandising rights. Your sports merchandising, it represents one of the largest revenue streams for professional leagues and clubs. Your jerseys, caps, sports equipment, posters, trading cards, digital collectibles, accessories, memorabilia, all generate, significant income. However, the right to manufacture and sell these is not automatic. It is usually governed through merchandising agreements and intellectual property licenses. Now, the owner of the trademark, logo, mascot, or team branding licenses, uh, those rights are given to the manufacturers and retailers under very carefully drafted agreements. These agreements regulate quality standards, royalty payments, manufacturing specification, geographic distribution, anti-counterfeiting measures, auditing rights, and termination procedures. So when you talk about counterfeit merchandise, it's a very major scam worldwide. So sports lawyers, they generally initiate um, regular legal proceedings against manufacturers and distributions who sell unauthorized products, to protect the trademark. Another legal, relationship that is there between the athletes and the team is your tour agreements. So when a sports team, it travels internationally, multiple agreements, they come into picture simultaneously, like the host association, the visiting association, broadcasters, sponsors, hotels, airlines, security agencies. You have your insurance, you have your ticketing platform, event management companies. They all execute separate contracts governing their respective obligation. So agreements, they usually address the scheduling, your venue allocation, travel logistics, accommodation, player security, medical facilities, your broadcasting arrangement, commercial rights, ticket, revenue, insurance, visa compliance, taxation, force majeure, and dispute resolution. Now, if there's a political unrest, natural disaster, pandemic, or security concern arises, these agreements determine whether the tour may be postponed, relocated, or cancels, and who bears the financial losses for the same. Another, the most ignored agreement or the most unknown agreement is your appearance agreement. So athletes are often invited to participate in exhibitions, award ceremonies, charity events, product launches, for fan engagement sessions, corporate conferences, etc. Appearances agreement, they specify the duration of the appearance, that whether you're going to appear for 1 hour, 2 hour, or a day, what is expected activity, photo shoot, meet and greet, remuneration, travel arrangement, publicity, obligation, cancellation terms, confidentiality, IPR rights over photographs and recordings. Similarly, nowadays athletes have been, participating in social media campaigns. So modern endorsement agreement, they often require athletes to, publish promotional content on Instagram, uh, and other social media. Now these obligations are specifically incorporated in the contract, including the number of posts, timelines, hashtags, disclosure requirements, and compliance with the uh, advertising regulation. So sports law today, therefore, it extends well beyond the playing field. It encompasses the intellectual property law, advertising law, employment law, taxation, contract law, competition law, privacy, and increasingly technology law. Your AI, deepfakes, virtual influencers, digital avatars, NFTs, fantasy sports, immersive broadcasting technologies are creating entirely new category of commercial rights that sports lawyers must now address. So the future sports lawyer will not merely negotiate the player salaries. They will advise clients on data rights, biometric information, AI generated content, digital licensing, um, merchandising, blockchain based collectibles, your esports, cross border media transactions. Now, as the sports industry, it continues to grow, um, evolve, legal professionals who understand both the commercial strategy and technology will be exceptionally high in demand. uh, so if you have been watching the series from beginning, by now you do understand that sports law is more than resolving disputes on the field. It's an integrate combination of let's say contract, IPR, media law, corporate law, competition law, taxation, technology law, employment law, and international commercial law. Now, let's begin with what exactly does expiration of broadcasting rights mean. We spoke about how you get broadcasting rights. Now, let's talk about what happens when it expires. So, a broadcasting agreement is never permanent. Okay, it is always for a fixed duration that it is executed. For example, a broadcaster may acquire the rights to telecast and stream a sports league for 3 years, 5 years, or another agreed term. What When the contractual period it ends, the broadcaster no longer has the legal authority to telecast the tournament until and unless a fresh agreement has been executed between the broadcaster and the whoever is the organizer. Uh, this is known as expiry of the broadcasting rights. Now, many viewers assume that because they have always watched a tournament on, let's say, one particular sports channel or an OTT platform, the broadcaster will do it the next year also, or it will be done uh, for perpetuity. But legally speaking, the broadcaster's authority exists only for a duration which is specified in the contract. And once the license expires, all the licenses, uh, you know, all the licenses rights revert to the rights holder unless the agreement provides otherwise. Now, the broadcaster must immediately stop using the licensed content until it has secured a renewal or another lawful basis for its continued use. So, what exactly happens after the contract expires? So, after expiry, the rights holder has got several options. The first option is, of course, renewal. If both the parties are satisfied with the commercial relationship, they may negotiate an extension or execute a fresh agreement. The second option is inviting competitive bids from multiple broadcasters. The process generally, it generates higher commercial value because several companies compete against each other to acquire these exclusive rights. The third option is always retaining the rights and launching the organization's own streaming platform. Many sports organizations are increasingly considering direct to consumer digital platforms rather than relying on exclusive traditional broadcasters. So each option involves extensive commercial negotiation, which is supported by legal due diligence. Let's talk about media rights auction process. Now, let's understand how exactly these rights are sold. So, sports media rights are generally awarded through competitive bidding. The organizers appoint financial advisors, legal advisors, media consultants, and technical experts. A tender document or request for proposal, which is commonly known as an RFP, is prepared. Now, this document, it specifies the tournament schedule, territories, available rights, packages, production obligation, your technical standards, payment timelines, compliance requirement, eligibility criteria, confidentiality obligation, and dispute resolution provision. Interested broadcasters purchase the bid documents and conduct their own due diligence. They analyze audience numbers, advertising potential, subscription forecast, production cost, technology infrastructure, competition, and expected profitability. Following this evaluation, they submit the commercial bids. The organizer evaluates these bids based not only on the price offered but also on financial capability, the technological expertise, broadcasting experience, production quality, regulatory compliance, and long term commercial strategy. The successful bidder is then awarded the media rights through a comprehensive media rights agreement. Now, why do broadcasters pay such a huge amount? So, this is one of the most frequently asked questions. How can a broadcaster justify spending thousands of crores merely to show a cricket or a football tournament? The answer lies in your commercial economics. Live sports generate exceptionally high viewer engagement. Unlike movies or your television series, um, sporting events are often watched live. People rarely wait several days, before watching the final of a major tournament. Because millions of viewers watch simultaneously, advertisers are willing to pay premium rates for your commercial slots. Broadcasters also earn revenue through subscription fees, digital membership, international syndication, your sponsored content licensing, and cross-platform advertising. In many cases, sports broadcasting becomes the foundation upon which an entire streaming platform builds its subscribers base. Let's talk about legal issues during media rights auction. Now, media rights auction frequently give rise to a lot of legal disputes. So, one major concern is your bid rigging. That is, if competing bidders, they secretly coordinate their bids of competing fairly, and competition laws may be violated. Another issue is, of course, your breach of confidentiality. So, unauthorized disclosure of confidential information. Sometimes, during negotiation, broadcasters do receive commercially sensitive information. Now, disputes also arise regarding interpretation of tender conditions, qualification requirements, force majeure, payment defaults, production obligation, exclusivity provision, sub-licensing restriction, and intellectual property ownership. Consequently, lawyers remain involved throughout the entire bidding process, from drafting the tender documents until the execution of the final agreement. Now, let's talk about piracy, the biggest threat for sports broadcasting. One of the greatest challenges that broadcasters are today facing is the uh, concept of digital piracy. So, every major sporting event is legally streamed on an authorized website and mobile application. Some individuals record television broadcasts and upload them on social media platforms within minutes. Others create illegal streaming services that attract millions of viewers. This causes enormous financial losses. Now, sports organizations invest billions in producing world-class sporting events. Broadcasters pay, substantial license fees. So sponsors pay premium amounts to advertise live matches while illegal streams become available. Legitimate, revenue declines significantly. Now, to combat piracy, broadcasters rely upon copyright law, technological protection measures, watermarking technology, digital fingerprinting, blocking orders issued by court, platform takedown mechanism, and international enforcement cooperation. Modern sports lawyers, therefore, require not only legal knowledge but also understanding of cybersecurity and digital enforcement strategies. So, let's talk about artificial intelligence and the future of sports broadcasting. Now, artificial intelligence is transforming sports broadcasting at an extraordinary pace. AI is already generating automated match highlights, multilingual commentary, predictive analysis, player performance strategy, virtual graphics, personalized recommendation, and automated content moderation. Now, broadcasters have been using AI to identify the exciting moments during the matches and instantly create a highlight package for digital platforms. Now, machine learning algorithm uh, analyze the viewer behavior and recommend your personalized content. So, your virtual advertising technologies replace the stadium advertisements depending on the viewer's country. This means that viewers from India may see a different advertisement from viewers who are watching the same match maybe in Europe or America. However, AI also raises significant legal concerns. Who owns the AI generated commentary? Can AI replicate a famous commentator's voice without permission? Who owns AI generated sports highlight? Can broadcasters use athletes' biometric data without informed consent? Like, can uh, AI generated avatars commercially exploit a player's likeliness? These questions are something that is going to define the next generation of sports. Now, let's come to the most awaited question that a lot of law students ask me. What are the career opportunities in sports law? Many students ask whether sports law offers meaningful career opportunity. The right answer is yes. Sports law today advise, sports lawyers today advise federations, professional leagues, franchise owners, athletes, coaches, sports management companies, OTT platforms, television broadcasters, event management companies, advertising agencies, sponsorship consultant, talent management agencies, equipment manufacturers, gaming companies, fantasy sports platform, esports organization, international governing bodies. The law, the demand for specialists is growing because sports has become a global commercial industry worth billions of dollars, and law firms are increasingly uh, they maintain sports law as a dedicated practice. Corporate legal departments recruit lawyers specializing in media rights and sponsorship mostly, and international arbitration involving sports dispute, it continues to expand every single day. So, for lawyers or law students who are interested in media law, intellectual property law, corporate law, technology, or international law, sports law offers a high rewarding multidisciplinary career. Now, here is a few advice I would like to give your students, especially if you're planning to build a career in sports law. You need to begin today. You need to read the player agreements, study what are sponsorship contracts, analyze broadcasting agreements whenever they are made available publicly. You need to follow the different developments involving sports governance, understand intellectual property law, learn contract drafting, improve your negotiation skills, develop familiarity with the arbitration procedures. You need to read decisions that are delivered by the sports tribunal and arbitration bodies. You have to stay informed about the development in artificial intelligence, data protection, digital media regulation, and emerging technologies, because these subjects are increasingly connected with the sports law. Most importantly, you need to remember that opportunities rarely come to those who simply wait. You have to create opportunities, write articles, publish legal research, attend conferences, volunteer at sporting events. Complete your internship with sports organization, media companies, law firms, broadcasters, and technology companies. The sports industry values professionals who understand both the law and the business of sports. Now, as we conclude this masterclass, let me leave you with one final thought. Every sporting event that captivates millions of viewers is supported by an invisible legal frame. Before the first ball is bowled, before the referee blows the whistle, before the opening ceremony begins, hundreds of lawyers, commercial advisors, broadcasters, sponsors, technology providers, regulators have spent months, sometimes years, negotiating the legal architecture that makes this event possible. So, sports law is therefore not confined to disputes and litigation. It is about creating certainty, protecting commercial interest, fostering innovation, safeguarding IP, ensuring fair competition, and enabling the global sports economy to function efficiently. If you're passionate about law and fascinated by the business of sports, this is one of the most dynamic and rapidly evolving fields you can pursue. So, thank you for joining me throughout this sports law masterclass. If you found this session valuable, please like this video, share it with your friends, and subscribe to Law School Uncensored for more in-depth discussion on media law, sports law, IPR, startup law, technology law, and other emerging areas of legal practice. If there is any specific legal topic you would like me to cover in a future masterclass, please leave your suggestion in the comments below. Until then, keep learning, keep questioning, and remember that law is not merely a profession. It's a foundation upon which the modern society and global commerce are built. Thank you so much for watching, and I'll see you in the next video.